Welcome to The Explainer. So today we're tackling a topic that sounds incredibly simple when you hear it on the campaign trail, but gets wildly complicated in actual practice. We're talking about deregulation. Politicians across the spectrum are constantly promising to swiftly cut red tape. But the administrative reality of actually doing that? Well, it turns out it's a fascinating and just deeply rigorous legal process.
Okay, let's dive right into this. Here's the central question we really want to answer today. Is it harder to write a rule or erase one? You see, we hear so much about the political promises of unmaking rules, but right now, we're shifting our focus to the grueling uphill legal battle of actually getting it done. Because as you'll see, tearing down a regulation requires just as much, if not more, legal scaffolding as building one from scratch. Here is our roadmap for the explainer. First, the promise of deregulation. Second, the courtroom reality check. Then we'll hit hurdle 1, the courts. Hurdle 2, Congress. And hurdle 3, agency revisions. Finally, we'll wrap up with the long-term legal impact. All right, kicking things off with Section 1, the courtroom reality check. Expectation versus reality. Now, what's really interesting here is the massive gap between the expectation of swift deregulation and the actual track record in the judicial system. According to an analysis by the Brookings Institute, federal agencies historically enjoy a pretty robust win rate of about 69% when their rules are challenged in court. But during the Trump administration, when researchers looked specifically at deregulatory actions, that win rate plummeted to just 5%. 5%! To put that staggering drop into perspective, out of 19 challenged deregulatory actions analyzed by Brookings, an incredible 18 resulted in losses in court or were just completely abandoned by the administration. 18 out of 19. This tells us that fast-tracking deregulation often hits a massive brick wall in the judicial system. But why is that? Well, to understand it, we have to look at the specific hurdles. Which brings us to hurdle 1, the courts. The judicial system heavily scrutinizes executive attempts to simply bypass established rules, and they hold agencies to incredibly strict standards. A really fascinating example of this is a 2026 attempt regarding the Public Service Loan Forgiveness Program. According to a report by The Guardian, the executive branch tried to redefine what constitutes public service work, specifically to exclude organizations that they deem to have a substantial illegal purpose. The executive order argued that the program had, quote, misdirected tax dollars into activist organizations that not only fail to serve the public interest, but actually harm our national security and American values. So what happened next? Well, Democratic-led states and nonprofits immediately sued, and a federal judge in Boston quickly sided with the challengers, blocking the rule entirely. Now, this kind of thing happens so often because of what's known as the Mandatory Administrative Procedure Act loop. You see, courts require this relentless, strict procedural cycle. If an agency wants to delay or erase a rule, they absolutely cannot just flip a switch. It doesn't work like that. They have to formally explain their rationale, open it up to public comment, and then rigorously respond to every single critique they receive. Skipping these steps, that's almost a guaranteed loss in court. Moving on to hurdle 2, Congress. So while courts often block those executive shortcuts we just talked about, the legislative branch does actually have a mechanism to instantly vaporize an existing rule. Though catch this, it requires absolute perfect political alignment. It's called the Congressional Review Act, or CRA. Essentially, it allows Congress to pass a joint resolution formally disapproving of a federal rule. And if that's signed by the president, the rule is completely stripped of its legal force. It's basically the legislative equivalent of dropping an impassable roadblock right on top of a regulation. We can actually see the CRA in action with the OCC's True Lender Rule. Look at this timeline. The rule was originally finalized in October of 2020, but fast forward to May 2021, and the Senate voted to disapprove it. The House followed suit in June, and the president signed it shortly after. So in less than a year, the rule was completely wiped from the Code of Federal Regulations. Poof, gone. But remember, this nuclear option literally only works when the House, the Senate, and the president are all in total, absolute agreement. That takes us to hurdle 3, agency revisions. When Congress isn't perfectly aligned and the courts are demanding those rigorous procedures we discussed, agencies are forced into a grueling, incredibly slow internal process. They have to scale back rules rather than just destroy them entirely. Let's look at a detailed analysis by the law firm Mayer Brown regarding the Consumer Financial Protection Bureau. Under the Dodd-Frank Act, the CFPB issued a really broad rule in 2023 requiring lenders to report data on loans to small, women-owned, and minority-owned businesses. Well, after facing immediate litigation, they had to go back to the drawing board and issue a revised final rule in May of 2026. And this brilliantly illustrates how deregulation actually happens in the real world, through very careful trimming. The CFPB internally scaled back the 2023 rules significantly. Look at the gross revenue limit for a covered small business. It plummeted from $5 million down to just $1 million. The threshold for a covered lender jumped from originating 100 loans way up to 1,000 loans. Plus, they explicitly carved out exclusions for merchant cash advances and agricultural lending. And they didn't stop there. The 2026 final rule completely stripped out discretionary data points like pricing information and denial reasons. They gutted those subjective anti-discouragement monitoring provisions. And, crucially, they delayed the mandatory compliance date all the way out to January 1st, 2028. So the core requirement to collect data definitely survived, but in a heavily reduced, much less burdensome form. As the CFPB themselves stated at the time, the updated threshold, quote, strikes the right balance between maintaining broad coverage of small businesses and reducing regulatory burden on financial institutions. So the crucial takeaway here is that successful agency deregulation is rarely a total erasure. It's almost always a negotiated compromise and a slow recalibration.
Finally, Section 6, the long-term legal impact. So what does this all mean for the future of our government? Well, the Brookings Institute puts forward a pretty fascinating concept. Administrative law is a common pool. This basically means that legal precedents set by one agency actually apply to and restrict all other federal agencies. So think about it. If the EPA loses a court battle because they rushed a deregulatory rule, that creates a shared precedent. And that precedent is going to restrict how the Department of Education or the CFPB or literally any future administration attempts to deregulate across the board. Which leaves us with the new realities of deregulation. Because of these recent court rulings, indefinite delays of rules are going to face strictly intense judicial review. Agencies are practically forced to accept public comment, even if they just want to delay a rule. Ultimately, deregulation requires significant time, effort, and immense legal rigor. It is absolutely not something that can happen overnight.
Which leaves us with this final, really provocative thought. We've seen that the legal precedents set by these recent battles ensure that unmaking administrative law is going to remain an incredibly steep uphill climb. But is that a good thing? If unmaking laws is this difficult, does our system actually protect us from administrative chaos, or does it permanently trap us in red tape? It's a vital question to keep in mind the next time you hear a politician promise to erase the rulebook on day one. Thanks so much for joining me on this explainer, and keep learning.